first and foremost, as a homeowner, I mean, if you're having an issue with the common area pipe, notify immediately and notify in writing.
Sure.
Because once that notification goes over to the association, there's an obligation on that association to do something. And typically it's inspect, to get someone out to look at the issue. Really, really bad associations don't even do that. They ignore. You're sending them requests. You're saying, hey, I have this problem. There's a leak. There's a pipe that I believe is broken. Whatever it is, the notice goes to the association. They won't even send someone out to inspect that. That's very problematic. But then the second tier is they'll send someone out who inspects it, and they don't do anything with the information.
That's probably the most egregious.
I would argue that, yeah. Or on occasion, they send out someone who's just not qualified. You have a massive problem with the roof, and next thing you know, a handyman who has no business looking at a roof is up there with a flashlight and some duct tape. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Ellis Carlson Law, and welcome back to the show. Today, we're going to be really diving into failure to repair. And we see that time and time again, especially in our practice. This is a very common dispute, but I think it'd be worth going over it with our viewers and our panel to discuss failure to repair. Jenny, welcome back to the show.
Thank you for having me.
And Marty, welcome back.
Thanks.
All right. So, Marty, I typically kick it off to you. How would you like to start this dispute type topic?
Well, I think it's pretty easy. I think we need to define what failure to repair is, even though it's fairly well defined in the definition, but from a legal perspective, I think it would be beneficial.
Yeah. So, failure to repair, I'm trying to think of an example where it wouldn't be this, but 99.99% of the time, it's going to be a common area. So a failure to repair from our perspective is the association has failed to do something and repair something in a common area, right?
A common area would be like a pool, a green belt, a playground.
Precisely. Green belt. The biggest one that we see over and over again is a common area roof or common area pipes.
Oh, for like a condo?
Correct. That's very typical. And then, of course, in a green belt or a slope, a failure to repair a common area slope. Those are often big damages because you have a slope, let's say it's crumbling, and your house is, on top of that could cause pretty massive damage.
But it could be the inverse too. You could, if there's drainage issues, it could be
correct
water
intrusion on the other side.
So failure to repair is an association failing to repair a common area element. I think that's maybe the simplest way to look at this topic.
Okay.
So, but again, common areas is what we're looking at.
Okay. Let's go through some of these specifically. So, there's landscaping. So out here we have a lot of fires. So I would assume that, I guess your guys' HOA is probably pretty primed for this. If the hillside is riddled with bush weeds and things, it could be a fire hazard. Is that on the HOA?
Yeah, so that could be a negligence claim if they know about it, especially if the fire department, sometimes a fire department will actually go out, inspect a slope, and give a recommendation to an association. And if they don't follow that, that could be very problematic for the association.
Do they get fines for that? Or
They could
get fines?
Yeah, there could be, the city could impose fines. And, you have fire, which is a big one. But what we frequently see, especially when a big storm comes in, is water intrusion. So there might be an issue with the drain, a common area drain. So, that's supposed to be maintained by the association. And the association has just failed to unclog it or address it. And what happens is when it rains, it clogs, water builds up, and next thing you know, it's leaking into the property. So that would be a prime example of a failure to repair. And it's sort of a failure to maintain and repair, like just common maintenance, right? That's what we're also looking at.
I feel like that's the key to everything.
Yeah, a well-oiled machine, a well-oiled association, they're the ones who have a maintenance schedule. Every year they go out, they look at the roof. Every year they look at the pipes, but they're often, bringing in an expert, and the expert will opine and say, hey, this is what we need to do with the roof. It's not necessarily the board has to come up with this, but some expert, someone who understands this area, should opine, give them an opinion on this, and then the board runs with it.
Sure.
That's ideal.
An example, we had a fireman in our neighborhood in a traditional truck, not a fire truck, but like a Ford F-150, and he was going around doing, I guess they give yearly recommendations.
Yeah,
But that was kind of beneficial.
And that's great that the association is doing that. They're taking the extra mile. They're
Going
outsourcing
extra.
those decisions.
Sure.
And so, that's one way of getting that information. The other one, though, is if you're a homeowner and you're seeing this, you're notifying the board. You're putting them on notice. Hey, this French drain keeps backing up. This slope appears to be problematic. I'm having cracking in my home. We saw a case like that several years ago, and the homeowner continuously put the association on notice that there's something off with the slope. It needed to be shored up. The association ignored all the requests, and it turned into a massive dispute. So that's what we're looking at.
What about something like a security gate? They decide not to. It comes in disrepair. They leave it open for 2 years, and then you have a string of robberies and things along those lines. That
security gates are interesting because I've seen many CC&Rs that identify the security apparatus as an aesthetic attribute to the property. They qualify it differently, and they don't. In the CC&Rs, they specifically say we are not guaranteeing any security. Any security feature is aesthetics. It's just for I don't know.
Increased property value.
Maybe, well, not that, but they're sidestepping a security obligation.
I love that. Even if they have a guy that has security on the back and driving the golf cart around.
Well, there's different types of security.
Sure.
You have a guard at some communities, but if you read the CC&Rs, the guard is not there to provide security to the property. It's to monitor ingress, egress. They'll actually define what their job title is.
Interesting.
So again, that's the association trying to sidestep any sort of obligation to provide security to the association.
Well, I always think about neighborhoods that don't have a person manning the front, that it was just a gate. If there's any kind of maintenance issues with that gate, how do people get in and out? I feel like that's huge.
There's different types, I suppose. I mean, sometimes the gate's broken because it's just left open.
Right.
Sometimes it doesn't open and close correctly. I think when it's actually blocking ingress, egress, the ability to leave or enter, that's fixed pretty quickly.
Right.
Yeah.
It has
right.
to be.
That's sort of immediate.
Yeah. If homeowners can't get to their houses.
Correct. Or the board president can no longer get to his or her house.
His or her house.
That's you're gonna probably get that fixed pretty quickly. So all right. So that's structural repairs.
We have utilities and services.
Yeah, water lines, sewage systems, these all become potentially massive liabilities for the association when they're poorly maintained.
Yeah.
And the way to approach it, first and foremost, as a homeowner, I mean, if you're having an issue with a common area pipe, notify immediately and notify in writing.
Sure.
Because once that notification goes over to the association, there's an obligation on that association to do something. And typically it's inspect, to get someone out to look at the issue. Really, really bad associations don't even do that. They ignore. You're sending them requests. You're saying, hey, I have this problem. There's a leak. There's a pipe that I believe is broken. Whatever it is, the notice goes to the association. They won't even send someone out to inspect that. That's very problematic. But then the second tier is they'll send someone out who inspects it, and they don't do anything with the information.
That's probably the most egregious.
I would argue that, yeah. Or on occasion, they send out someone who's just not qualified. You have a massive problem with the roof, and next thing you know, a handyman who has no business looking at a roof is up there with a flashlight and some duct tape, right? That's inefficient. So you almost have to look at who are they sending out as well. That's important.
Yeah.
What quality, what qualifications do they have given the repair issue?
And we touched upon that in previous episodes.
Yeah.
With the choice of hiring.
Yeah. You got to get the three.
The three. The three, and you pick the middle one.
Oh, bidding
yes,
out.
Bidding out.
Yeah. But again, I think that goes to qualification, and there's somewhat of a reasonable standard. I mean, you don't send out a professional pool cleaner to inspect a roof.
Sure. Do a lot of CC&Rs define maintenance inspections in the CCNR. Like
I've seen it before. They'll actually put a schedule in. Oftentimes, the CCNRs will mandate a repair and maintenance requirement on common area, and then what the board will do is they'll generate some sort of schedule, which is perfectly fine.
Sure, and I mean that seems prudent, and it probably has. If they have experts and they've gone to that length, they usually budget for repairs of
usually
said things.
Yeah,
because I see a lot of disputes kind of break out of, oh, we didn't budget for that, and they're going to just raise dues in order to cover it.
Yeah, and sometimes that becomes a financial mismanagement issue as well. So that can create, if you go deeper on those issues, let's say you have common areas that are falling into a state of neglect. You say, well, why is this? It's not necessarily that the board is unaware or unwilling to take action, but years and years of financial mismanagement has brought them to a point where they can't afford to do anything.
Yeah.
And that becomes its own sort of legal issue unto itself. So,
much to unpack.
Oh my gosh, yeah.
These become rabbit holes pretty quickly,
yeah,
if you will. So, yeah, that is generally what we see from a failure to repair perspective. I guess your next segment is legal implications.
Yeah. So what legal responsibility does the HOA have to maintain, or what is their requirement to maintain these common areas?
So it
really depends, I assume, on the CCNRs.
Well, yeah, you look at the CCNRs, but I'll give you a straightforward one. It's a common area, greenbelt, and the association has the obligation to maintain and repair. Okay, that's pretty straightforward.
Is that fairly well defined? Like, oh well, at the bottom of it, there's a drain, and we're not responsible for that. Like, is it very well defined?
It typically is. And if you're talking about a greenbelt, common area greenbelt that has a French drain in the middle, then the contractual obligation would be to maintain that as well.
Sure.
Because if you look at it from a legal perspective, even if a homeowner knew about a backed up French drain, they wouldn't have the legal right to tamper with it.
Yeah.
It's not theirs. It's not their property.
Yeah.
So the only entity that would be permitted to do so would actually be the association. Mm. So the burden is on them, and legally they're the only ones who can act. So yes, to your point, if it's common area, it's those elements within the common area as well that fall under the purview of the association.
Sure. So in terms of, resolution, we've gone over this before, but for the people that have not seen previous episodes, and they're really hyper-focused on particular issues. Yeah, because they have
a failure to repair issue.
Yeah.
So, let me back up too, because you got to look at the association. At least in California, courts are not going to micromanage a board necessarily, and they're going to give deference to a board regarding certain business decisions. So a board has the right to, make decisions regarding repair and maintain standards. They say, hey, you know what? If we maintain and repair on every other year, that might be okay so long as the board can identify an expert who's gave them the recommendation. Yeah. Boards get in trouble where there's just no action. They don't have anything. They've never deferred to a third party expert. Or even worse, they've been put on notice by a homeowner of some sort of massive issue. Maybe it's water intrusion, maybe it's a pipe leak, and they've done nothing. They've ignored that request, even though someone's getting flooded and there's property damage that's ongoing. That is where the board is, breaching the CCNRs, most likely. That's where you're probably also going to find a negligence claim as well, because they fell well below the standard of care, and you might even be in breach of fiduciary at that point. Right? The board owes the homeowners a fiduciary obligation, which is a heightened standard of care. So if a board is well aware of an ongoing water intrusion issue that's just wreaking havoc on a condo or on a home, then you're going to have these causes of action to bring against an association, most likely. Now, you're talking about resolution, though.
Yeah.
What do you do?
So I'm sure there's different levels, because having an issue with the jacuzzi that's the heater hasn't worked for 6 months is different than if you've got a leaky roof in a condo and it's now impacting your property. There's one that has actual damages associated with it, and then there's one that's lower, it's quality of life, but not that
yeah, we discussed this before. So you almost take a spectrum and you say, what is the impact? And it's typically two forms of impact. You have economic impact, and you can take that on a spectrum, and you also have quality of life spectrum.
Sure.
Right. And I think that sort of gauge that should help a homeowner navigate how they're going to approach it. If it is sort of displacing you and causing hundreds of thousands of dollars of damages, that's a huge impact.
Yeah.
And so that's where you may want to go in very, very aggressively.
And as a non-lawyer who's not aware of what would be the proper steps, should somebody just put something in writing first and to their board?
Well, okay, so let's use an example. Let's use the
Let's use two examples. One on the kind of higher end spectrum of there's water intrusion, and then one like the pool doesn't work.
All right, so let's do the high end impact.
Yeah.
Water is flooding a property, and the family is displaced. They're living in an Airbnb now.
Yeah.
They've put the association on notice, and the association has said, "Go kick rocks. We're not going to do anything." I would argue it's straight to lawyer at that point.
Okay.
If they're not listening to a homeowner, especially with that sort of extraordinary set of circumstances, that egregious, I highly doubt you're going to be able to do anything and get traction. I think you bring in the big guns, you go hyper aggressive, and you go for the jugular. You force them to move on that. Because if they're aware of this and you've already put them on notice, they should act. And if they're not acting, there's a real problem. So that's, I think, the extreme.
Right.
That's a knee jerk to go to the hired gun. Now you go to the less extreme, broken jacuzzi.
Quality of life.
No, like roll that back just a little bit,
Okay.
actually, because I think there's probably a fair amount of people that don't get displaced right away, but there's water intrusion. You could see the paint starting to peel in their wall. Clearly, there's water coming in. So what would be their step? I would assume document first, and then alert the board in someone at
Okay,
the HOA.
I went very extreme.
Yeah,
very
so
quickly.
roll it back.
I saw the worst in that situation.
roll
Okay,
it back
let's
like
go a
2
little bit
clicks.
less worse than what you're saying. Let's just bring it a little bit back on the spectrum. So now you're in your home, water intrusion starts. Okay, let's say it's common area. You're getting flooded. First thing you're going to want to do is get an expert out to at least see what they can do to stop it. Right? You want to do everything you can to limit the damage. As part of that, though, there's a documentation process, and then I would say concurrently, you're putting the board or most likely the management company on notice. And whatever documentation that you're getting, whether it's photo, video, or expert reports from the person you had come out to address the water intrusion issue, those are being sent directly to the management company or the board or both. That's step one. Now, a well-functioning association will likely kick into gear very quickly. They'll send someone out to inspect the common area, see what the actual issue is, see how it needs to be addressed or remedied, and then maybe start working with the homeowner regarding repairs of the unit.
Do they get in a bit of a squabble between whether or not the HOA is going to make you whole versus you need to talk to your homeowner's insurance?
Yeah, that's the lightning rod of these typically.
Yeah.
Because what happens is you have a homeowner whose home is repaired or destroyed, and they want the home to be repaired.
Yeah.
So they go to the association. The association says, "Hey, it's not our problem." Homeowner says, "Well, no, according to my expert, it was because you failed to maintain this common area drain.
Yeah.
The drain backed up. I got flooded." Association says, "No, that's your responsibility." So a homeowner will then go to their insurance company, submit a claim, and submit the report from their expert who came out. And the claim will get denied on the basis that it wasn't the homeowner's negligence, it was the association's negligence that caused the damage. Because if you look at it, now some policies are much broader and they might cover that, but your general policy isn't going to cover necessarily the association's negligence.
I remember this being an issue with our own condo. We had the pipe burst. We had a tenant in the condo, and our homeowners insurance actually did cover it, but they had worked with the HOA.
And sometimes they work concurrently, but a lot of these problems come in where the insurance company of the homeowner says, no dice, we're not going to help you. And now it's the homeowner versus association. And that's the tension, and that turns into the legal battle often.
Got it.
So that is that one.
So is I would assume that the HOAs have their own insurance to cover things like this.
They do. It's they often have E&O insurance, errors and omissions.
Okay.
So they're backed by that. And you got to look at, if you pan out from in association land, there is an assumption that the board, the directors are going to screw up because they're volunteers. They're going to, There's going to be errors and there's going to be omissions, right? It's sort of built into the recipe. Because again, where do they come from? It's not like, these are hand-selected candidates who are on the board and have had, many years at, Wharton Business School.
No, there's an email that goes out and they just ask for volunteers. As we just
correct.
learned.
And that's how it's engineered. And because of that, though, there's E&O insurances in place. Now, sometimes the board, though, doesn't want to go to the insurance policy and they try to kick it. They try to put it on the homeowner.
Yeah.
Because why? They don't want their premiums to go up. They don't want to deal with insurance. They just want to try to pass the buck. And, some homeowners who don't push back and they just swallow that pill, they end up dealing with it on their own, when in reality, legally, it really fell on the association. So associations get away with it until the homeowner fights back appropriately.
Yeah.
So problem happens, hire the expert, get it solved quickly, submit all the documentation to the board as quickly as possible, document everything to the extent that
Put everything in writing.
Everything needs to go in writing.
Yeah. If they don't do anything about it, it becomes a problem. Maybe that's the time to bring in a lawyer. But if they're willing to work with you, maybe you can work something out.
Yeah, listen, I'm of the opinion if you can work directly with the board without a lawyer, that's a win.
Yeah.
I love those outcomes. And I'm in the business of HOA disputes, right? But when I hear that an association works with a homeowner towards resolution and no lawyers are involved, typically that's a very well-functioning association.
It's a huge plus, yeah.
I love that.
But on the flip side, be careful of what you're signing, because I'm assuming you're gonna sign off some sort of like liability at that point. We have covered our liabilities here. No, we're not responsible for anything afterward, which could get yourself in a world of hurt. At the
Well,
same
I think
time.
that's a general rule in life. Don't sign anything without a lawyer present or have it reviewed. Now, you might be able to negotiate a resolution. Eventually, to your point, there might be a document that's put in front of you.
Yeah.
And at that point, spend an hour with the lawyer.
Yeah.
Have a lawyer just review it. Pay for an hour consultation, or some lawyers will meet with you for free.
Yeah.
So if you can get this in front of a lawyer, have them do a review, and if it's good, if it isn't one-sided, if it doesn't have any sort of traps,
Yeah.
great. If it is one-sided and there's a bunch of issues with it, okay, now the lawyer that you've identified can come in and might be able to start negotiating a more favorable resolution.
Got it.
So let's quickly hit the opposite end of the spectrum, where it's not in the damages realm, but it's in the quality of life realm. Is your approach different?
Depends on the quality of life impact.
It depends is my favorite answer.
You're
Every
I think
legal question.
every legal question is it depends. Yeah.
because it always depends. It does. It's not these questions are not binary in the sense that it's a yes or a no.
Yeah.
There's a lot that ties into it. And even if you can have a good legal understanding and say, hey, this is where I think it's going to track, and this is, your legal rights have been violated, that might depend, though, on who's on the other side of the coin.
Sure.
We might have a bunch of Rambo attorneys on the other side who are absolutely out of their minds. You got to factor that in.
Yeah.
So, yeah, I think it's one of those things that people joke about. It depends. But the reason why lawyers always say it depends is it depends on so many things.
So many factors.
You got the legal aspect, you got the factual aspects, you got the human side of things. So
Yeah.
I went on a tangent. I don't recall.
Oh, we were saying
What did you just say?
On the quality of life spectrum, and you're saying, well, it depends.
Okay, yeah.
Yeah.
What sort of quality of life? How much has your quality been impacted? And sometimes it's very drastic. It's displacement.
But assuming that there's no damages. So let's assume that there's
We're going with the hot tub example.
the hot tub example. Like, I've been calling for like 2 years. I want my dang hot tub. This was
It's only
central
98
thing.
degrees, and I want it to be 102 like they promised.
Yeah, I don't know if you bring on a lawyer for that. That
Okay,
might be.
but let's say that you have brought it to the board's attention, and they do nothing, and they do nothing, and they do nothing, and now that's the point that you're just getting irritated and frustrated.
Are you going to follow the same steps where you document?
Yeah, exactly.
So let's talk about the hot tub. Hot tub doesn't work,
You laugh. I'm in that hot tub.
and you're very mad, and it's ruining your.
Quality of life.
And I see the argument because you're paying dues, and that's part of the amenities, and that's why you were sold, and that's why you like the community, and it's really important for your family. So I get that part of it.
Or the pickleball court's been shut down for 6 months.
Okay.
And you want to get
Tragic.
out there. I
Yeah,
mean,
you want to get at it.
with retirees.
All right, so yes, you document. I mean, typically documentation would be derived from the emails that you're sending. Hopefully,
We
you're
need
not
like
just
an
calling.
acronym of like of
Order
how to
of-
approach these.
yes.
Like
Document, document, call, document. DCD.
yeah, and then lawyer.
Yeah. No, but I think it's just that. It's just you send the emails, you build a file. On something like that, they might just ignore. They might say, hey, for whatever reason, we can't do it. We're missing a piece. I mean, eventually you're going to have a paper trail on this.
Yeah.
And then you have a question at some point. If you are getting no action, likely that's going to be some sort of breach of contract claim under the CC&Rs because they have an obligation to maintain and repair, right, including the spa. They're failing to do it, and there's no justifiable reason as to why. And maybe it's just they ignore it. Maybe the board president doesn't care about the spa because he or she, they never use it. It doesn't matter to them, right?
Yeah.
So your question then becomes, how much money are you going to throw at this? Because legal intervention becomes the next step. Do you want to hire a lawyer? Do you want to invest in a lawyer? Now, the alternative is, at least in California, you could go pro per, meaning you represent yourself. Maybe you initiate the ADR process, which we've discussed. Demand for alternative dispute resolution under the Davis-Sterling Act. If you hire a lawyer, that can be expensive. If you do it on your own, you might show up at the mediation, and they're going to have a lawyer on the other side. They might try to walk all over you.
Yeah.
That could happen.
Wasn't a good example of a quality of life issue that maybe you've seen in the past several years that isn't as silly as a hot tub issue? Not to offend anybody,
Yeah. All the hot tubbers out there.
But isn't directly related to damages, like with your own home? What's something that you've seen that might bring in a lawyer?
So we're under failure to repair. Putting that aside, if we're looking at quality of life, it could be some sort of nuisance issue that's ongoing.
Sure.
Now, bring it to pickleball, right? That's an interesting, because pickleball, the integration of pickleball in these communities has resulted in a whole line of pickleball related cases, specifically nuisance. Pickleball courts come in, you live right next to the court, and you're listening to pickleball all day long. And if you, it sounds funny, but can you imagine just all day listening to pickleball? And you get it. We've had situations where we brought out experts who do noise. They register the noise sound levels, and they're off the charts. So that's a nuisance. That's a quality of life. Now, there's not actual damage to the property, but there might be damage to the extent that you have to disclose that if you sell the property.
Sure, it could impact fair market value.
And you're looking at, let's say it's a $1 million property. Let's say it's a reduction of 10% or 20% because no one wants to live next to a pickleball court. That's 200 G's potentially.
Yeah. Right.
So it actually does become a property damage issue on the back end if you're looking to sell, because it could be a disclosure issue.
Interesting.
So that's quality of life that immediately doesn't have economic impact necessarily, but eventually
it absolutely could down the line. Is it a fair assumption that if it's a quality of life issue that HOAs aren't as prompt in having a proper response to quality of life issues, or does that seem to be the same?
I hear what you're saying. So essentially, if
what's the expectation?
If they get hit with a quality of life versus a property damage, economic one, I mean, both are impactful. Both require a response.
Okay, so
or
good
at least
HOA
an
will respond to
investigation.
both fairly quickly. Okay.
I mean, normally when I talk about an association, it's always bad associations. I never talk about good ones because they're irrelevant to me and what I do.
Except at your own house.
Correct. Yes. But so far, so good. I like our association.
Knock on wood.
I think we covered a bunch of preventative measures, and I think this is more specifically, targeted to homeowners. But I think we should go over a sweet Reddit post.
Oh, we love these.
Yeah,
my favorite.
All right, Jenny, kick
All
this
right,
one off.
do you want me to do it?
Yeah.
We should get Reddit swag.
I know.
You know what we're going to do? Teaser. We're going to do an AMA. So ask me anything, where we're going to hit up the same HOA subreddit and say, I'm an HOA lawyer, ask me anything. But within this subreddit.
That is very interesting.
And then the whole episode is going to be you answering the questions.
Oh, that's
everybody get excited.
Yeah. Anyway, coming soon.
All this. Okay.
All right, that's actually kind of cool. I like that.
Yeah.
Looking forward to that. Nice teaser, Marty. All right, a neighbor and I experienced a central line leak back in August. The plumber I hired out determined it fell under HOA's responsibility to fix. They fixed the leak, and it took restoration 2 months to start. They gutted my floors, kitchen, and bathroom. The restoration team subsidized a different company for the repairs, and they came out to do an estimate. The estimate has been sent to HOA. However, they haven't given the go-ahead because they don't recognize the new company. I explained, and they said they needed further clarification from restoration. They've been dodging restoration calls, and at this point, I feel a bit helpless. Is there anything I can do?
That's interesting. So
It's funny, you have not heard this, and it was very similar to the examples
Yes,
that we gave
it
earlier.
really
And he has
So some of the things that strike me first and foremost is that the leak is coming from, they said, a central line. That's probably a common area leak.
right.
And back to my point, this person hired a plumber. The plumber comes out, and the plumber has probably been trained to recognize what they can and cannot work on. And so what you don't want to have happen is your expert, your contractor, whomever, really interact with the common area feature. That could expose you to liability.
Interesting.
Because all of a sudden your plumber comes in and they wreak havoc on the central line that's not in your domain. You have no right to tamper with that.
Yeah.
That could be problematic to you. So I get lost a little bit in the fact pattern because they hire someone, and it sounds like they fixed the leak. I assume they being the person that they hire.
Yeah.
And took restoration 2 months to start. So that sentence is a little bit confusing.
Well, they stopped the hemorrhaging. The first thing they did was stop the bleeding.
But I'm wondering, it took two
and so at that point, now you need to rip up all the drywall. You need to replace floors.
Right. I'm wondering where restoration came from, though. Did they hire restoration? They must have.
Or, yeah, they probably did. The plumber, as I've gone through this many a times, the plumber usually has somebody that they say, hey, here, I have someone. Here's a couple people that you can call.
Yeah.
So a couple things. So essentially what they're trying to do is seek repair costs. Yeah. That's what they're trying to do.
They
got restoration. Right? They've sent it to the association, and the association is sitting on it.
I'm saying they don't recognize the new company.
Which I don't know what that is supposed to mean.
Right.
But maybe...
So my interpretation of it was they had a restoration company that, and usually restoration companies just rip all the crap out, right? They usually are the ones that just say, here's all the damaged stuff. We ripped it all out. And usually there's another party that comes in to do the repairs, puts new drywall in, puts new flooring in, does a bathroom.
Right.
But the restoration people they're drying out things. They're using their dryers. They're testing all the areas, rip it all out, say, all right, you're now good to go. All of the moldy whatever has been removed. The asbestos has been taken out. You're now good to repair. So they probably say, oh, well, the restoration company took it this far. Now they're done. Now someone needs to put the thing back. So they brought in the actual contractor to put the stuff back, and they don't recognize the contractor as being part of the scope of this job.
And maybe so. So the first thing that I would need to know is why did the central line leak? What was the result of that? Was it a result of failure to maintain? Was it a result of negligence? Because that's really going to be what's pivotal in this case.
That determines everything, yeah.
But to your point, what's interesting about this whole thing, based on what you said, the fact that the homeowner brought in the plumber, and the plumber did work on the house without HOA, it sounds like without the HOA knowledge or approval, and it's not their line to repair. If it's a central line, it's not the homeowner's to repair.
So they might have put themselves
and again, I'll analyze this under California law,
because
I have no idea where this is, and I can only analyze under California law. But assuming that is accurate, so there was a leak, they hire a plumber, the plumber busts open a wall and tackles that line, that could have been a misstep. The proper procedure should have been notifying the association of the problem. Now, you would have a right to at least open up the wall because it's your wall to open. I mean, I don't see an issue with that. But once that plumber opened it up and saw that line leaking, it should have been brought to the association's attention.
Well, let me ask you this. What if the plumber, and this is like a real situation where you don't know as a homeowner that this belongs to you just see, oh, there's a line in my bathroom against this wall. The plumber doesn't know that it's technically the association, and you don't know it's the association, and then come to find out it is after you've already repaired it, but they've meddled with the line, and you have total ignorance there.
There's ignorance is no defense. You can't plead ignorance as a defense to what you did. You can't say, "Well, I didn't know that." I mean, that's not going to save the day.
How can you not though? Because if it's your house and you think it's your line, and the plumber thinks the same thing, but it technically isn't, and now the expert doesn't know.
But that's like saying you didn't know the speed limit. You didn't see a sign. A cop's not going to say, "Well, okay, sorry, you didn't know." Like there is a
expectation.
And whether that's reasonable or unreasonable, I don't think that matters. The question is, can you defend based upon that? The answer is no. So yes, if you want to, we can debate like, well, that's so unreasonable. Well, then change the law. I mean, all I'm saying is you can't, interact with things and be in a situation where you said that you just simply didn't know. Now, normally in a condo, for example, there is sort of an obvious element to common area elements. So if a pipe is in your domain, right, within your space, it's typically your obligation. If you have to open up a wall and it's in between the walls of the condo, it's sort of obvious that that's likely going to be a common area element, right?
Yeah.
And so for a plumber to come out and not know, then you probably want to get a different plumber. You say to that plumber, leave.
It's hard because and sorry, this is a little personal because I'm in
Marty
the middle of a
some
repair
issues
right now for this very
repairs,
thing with my own
failure.
house.
I've hit a nerve with Marty.
You really have.
But what if you want to stop the hemorrhaging? It's now leaking to your house. That every minute that goes by, this thing is damaging your house, and now you got to call the board to shut off the water. When a plumber, all I have to do is cut it off, and the hemorrhaging stops. But they have no right to do so.
I'll put it this way. I think that's where you get into resorting to self-help. If you put the board on notice and you say, this is an absolute emergency, you call the emergency line, I need someone out immediately, and my place is getting flooded, and no one responds, you always assume a risk, but that might be worth, having your expert do that.
Yeah.
Right? I mean, it's what liability will flow from it, I'm not sure. But you have to.
Marty, just weigh your options.
It becomes a business decision.
Again, this is not legal advice.
that becomes a business decision. You got to make a business decision on that. There might be an assumption of risk doing it, but at the end of the day, you might save your entire property. So you got to make.
But you might get a new property if you let the whole thing flood.
Cheers to that, Marty.
And it was the HOA's problem. But that's another risk. God, isn't homeownership awesome?
It's just one big risk. Endless risk. So, all right. Well, that was Reddit. That was fun. I think I answered the question.
Yeah.
I think there was a misstep at the outset. That's probably what happened here.
All right. What's the next episode?
So, this is a good one.
Yeah, selective enforcement.
Yeah, selective enforcement is, we see it all the time. And just to give you an idea of what selective enforcement is or how we see it is.
Give us a little teaser.
Yeah, I'll give you a teaser. It's the targeting of one homeowner or a group of homeowners. And, normally what we see, bringing back the personality types, you get the tyrant board member who just doesn't like one person. And all of a sudden, that one person is getting fines. They're getting parking violations. They're the ones whose application never gets through. Selective enforcement. There's a, targeting, if you will.
But that sounds like a bit of quality of life issue, not necessarily damages.
It could be. Yeah. Well, if you're racking up damages with parking fines
like
violation notices,
don't give away too much.
Yeah.
Okay. I won't. I got very excited about that one. All right. Well, thank you guys, and look forward to seeing you next time.
Nice.